Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing business attorney with over 15 years of experience in helping business owners protect their intellectual property. Today we're going to talk about a problem that lots of business owners face. Imagine that you hired a designer to create a logo for your business. You love the design that was created, paid the designer for it, and have been using it in connection with your website and other marketing for years. But do you own it? Most business owners think that they do because they paid the designer for it and have been using it in connection with their business. Unfortunately, under US copyright law, you might not own it unless you took certain steps to transfer ownership of the copyright to you. Most business owners aren't aware of the risk until a problem arises, such as someone using their logo or the designer objecting to the use of the logo in certain areas. In this video, I'll walk you through the relevant portions of US copyright law, explain the issues, and show you what steps need to be taken to guarantee that you have ownership of your logo. And if you find this tip helpful, please make sure to like the video, ring the bell, and subscribe to the channel for more helpful legal tips for your business. Now let's get to it. The first question you probably have is, what is a copyright and why should I care? That's a great question. In the US, a copyright is a set of legal protections granted by law to creators of original works like logos and other types of artistic expressions. The copyright owner has the exclusive right to reproduce, distribute, display, make derivative copies of the original creative work, and various other rights like transferring ownership of the copyright to another party. If you don't own the copyright, then you don't have the right to take any of these actions without the permission of the copyright owner. Now here's the problem for you as a business owner. Under US copyright law, which is 17 USC 101, the default rule is that copyright ownership automatically belongs to the person who created the work as soon as the work is fixed in a tangible form like a drawing, a writing, a computer design, or something like that. This means that unless an exception applies and you took the right steps, your logo designer owns the copyright to your logo as soon as it was finished and put in final form. No registration was needed by the designer and nothing else needed to be done by the designer. She owned the copyright as soon as she created the work and finished it. Now, you might be asking yourself, what are the exceptions to the default rule and what steps do you need to take to get ownership of your logo? And that's a great question. And there are three possible exceptions that are most relevant for business owners. The first potentially relevant exception to the copyright default rule that the creator owns the copyright is if the logo was created by your employee as part of their regular job duties. Under US copyright law, if a work is created by an employee as part of their regular job duties, the copyright ownership belongs to the employer and not the individual who created it. This is the most common exception to the default rule that business owners take advantage of to claim ownership of the creative work that was created by someone else. Suppose, for example, that you have an employee who serves as a staff designer for your business, and she designed your logo and was responsible for placing it on your website, your brochures, and everywhere else in your marketing material. In these circumstances, you, as the employer, own the copyright even if that person exercised independent creative judgment or worked independently on it. It doesn't matter so long as those tasks were part of what the employee was supposed to do for you. This exception applies automatically, although you should have an employment agreement with the individual that contains intellectual property assignment clauses like we'll be discussing in a moment. However, this exception doesn't apply to independent contractors or freelancers. Unlike employees, independent contractors typically retain copyright ownership of any creative work they create unless there's a written agreement in place that transfers ownership to their client. But this written agreement must meet certain conditions and have the right clauses, which I'll be discussing in a moment. The second potentially relevant exception to transferring copyright ownership of the logo from the creator to you is the work for hire exception for works that were specially ordered or commissioned. This exception can apply to independent contractors in certain circumstances, but it is a very narrow exception and it's doubtful that it will work for a logo. To qualify for the work for hire exception for commissioned works, you must meet two requirements. The first requirement is that you must have a written agreement in place with the independent contractor before the work is created, and that agreement must explicitly state and have a clause in it that states that the creative work is a work for hire. Most business owners who actually have a written contract with a graphic designer usually have a clause in there that states the logo is a work for hire. If your written agreement doesn't have this clause, then there's no way it can meet this exception. But even if your contract does have a work for hire clause, the second requirement is that the creative work must fall into one of 9 specific categories. These 9 categories are as follows. The work must be a contribution to a collective work, a part of a motion picture or other audiovisual work, a translation, a compilation, a supplementary work, an instructional text, a test, answer material for a test, or an atlas. None of these seem to fit a logo created for your business. So even if your contract does contain a work for hire clause, the work for hire exception for commission works doesn't apply, and copyright ownership of your logo hasn't been transferred from the creator to you. The third possible exception that could apply to transferring copyright ownership of the logo to your business is to have a written agreement with the designer that specifically transfers or assigns copyright ownership to you. A couple of things to note here. First, the document must be in writing. Verbal agreements are not legally binding for transferring copyright ownership. Second, the agreement must be with the actual copyright owner, and it must be signed by the actual copyright owner. So, in the case of your logo designer, the designer must be the person who actually created the logo and must sign the contract. If the designer is not the creator or doesn't sign the contract, copyright ownership is not being transferred to you. To ensure that the designer is the creator of the logo, the written contract should have a representation from the designer that the designer is the creator and the owner of the copyright that's being transferred to you. Third, this does not have to be a completely separate agreement, although it can be. However, whatever contract you use should have a specific clause or specific language in the agreement that states that the copyright owner is transferring ownership of the copyright and any other intellectual property rights to you. This is more than just a works for hire clause, and the work for hire clause by itself is not enough to transfer ownership to you. It is a specific clause in the agreement that states that the copyright owner is transferring or assigning ownership of all of the rights associated with the copyright to you. A simple assignment clause will say something like, quote, designer hereby irrevocably assigns, transfers, and conveys to business owner all worldwide rights, title, and interest in and to the copyright and any other intellectual property rights in the logo, end quote. The language will obviously be dependent on the specific language in the agreement and what is being created for you by the designer. Now, usually the transfer of copyright ownership to you is contingent upon the designer receiving payment in full for the logo. But that's okay and expected. If you don't pay the designer for the logo, you certainly can't expect to receive ownership of it. Now, some of you might be wondering, what rights do I have if none of these exceptions apply? And the answer, of course, is, like always, it depends on how your logo was created. If your logo was created by a designer who was an independent contractor, but you don't have a written agreement, then you have an implied license to use the logo for some intended purpose. Implied licenses are created when two parties engage in conduct where it's clear that the copyright owner is granting some type of license to the other party, but the exact terms of the license are not specifically agreed upon, and it needs to be implied from the conduct of the parties. A couple of things to note here. First, implied licenses are not ownership, and copyright is clear that ownership can't transfer without a written agreement. If you recall, copyright ownership gives the owner a whole bunch of rights to the creative work, such as the right to display it, make copies of it, transfer it to others, and various other rights. All of these can't be transferred to your business without a writing, no matter what you think the designer is doing. Second, the implied license being granted to you is only for a particular purpose, which is determined by the conduct of the parties. So, if you hired the designer to create a logo for your website and business cards, and the designer made the logo for these purposes, you have the right to use the logo for these limited purposes. However, it's not clear whether you can also use the logo for other purposes, such as for your t-shirts, your coffee mugs, or other marketing material. Third, the implied license is non-exclusive. This means that the designer can continue to use the logo for its own purposes and even sell it to somebody else, including a potential competitor. So if your logo was created by a designer and you don't have any kind of written contract, the scope of your rights is uncertain and it depends on the circumstances. This can be a real mess if there's ever a dispute between you and the designer, or you and any third party who might also be using your logo. Resolving the dispute would likely involve expensive and messy litigation, which nobody wants. However, If you have a written contract with a designer that has a works for hire clause, but not a copyright assignment clause, you might be in a slightly better situation. Although the logo probably doesn't qualify for the work for hire exception, since it doesn't fall into one of the 9 specific categories, you at least have a credible argument that the designer intended to transfer all copyright ownership to you. Case law is unclear on this issue, and the exact scope of your rights in the logo will depend on the other clauses in the agreement and the factual circumstances surrounding the deal. And if there's ever a dispute between you and the designer about whether you own the copyright, this will also likely involve litigation, which can get expensive and messy. Finally, if your logo was created for you by a freelance contractor found on the web, such as through Fiverr.com or Upwork.com, you're actually in pretty good shape. The terms of service on those websites provides that the creator transfers copyright ownership to the hiring party upon job completion and full payment. So if you got your logo through either of these websites or other similar websites, ownership of the copyright was transferred to you after you paid for it. One key point to keep in mind in this day and age, however, is to be very careful about using AI to create your logo. The US Copyright Office has made it clear that AI-created content can't be copyrighted. So if you use AI to generate your logo, you can't claim copyright ownership over it unless you made significant changes or modifications to it. This doesn't prevent you from obtaining a trademark for it, but it probably can't be copyrighted. Given the newness of AI and the slowness of the courts, I expect it will be several years before it all gets sorted out. So you might be asking, what do I do now? And there are 3 main steps you want to take. First, if you had a logo that was created for you, go back and take a look at the contract to see if there was a work for hire clause and a copyright assignment clause. If the contracts have these clauses, then you're probably fine, although you could always have a business attorney review the contract to make sure that you're protected and that you actually own the copyright to your logo. If the contract doesn't have a work for hire clause or a copyright and intellectual property assignment clause, or if you don't have any kind of written agreement with your designer at all, you need to consider whether it makes sense to go back to the designer to have them sign a copyright assignment agreement. These agreements can be signed after the fact, although it's not ideal. Be advised, however, that if you decide to do this, you will need to pay the designer some type of consideration to actually transfer copyright ownership to you. The consideration can be nominal, such as $1, or the contract can be signed under seal, which counts as consideration under Massachusetts law. Second, for any future independent contractor you hire, especially ones doing any type of creative work, you need to make sure to have a written agreement that contains both work for hire and copyright and intellectual property assignment clauses. Otherwise, you won't end up owning any of the copyright or other intellectual property rights for any work that they do for you. And don't assume that any contract presented to you by a marketing or design professional will have these clauses. Often, they're using contracts downloaded from the internet or obtained from some other source that don't have the necessary language to transfer intellectual property ownership to your business. Or what's worse, they don't plan on transferring intellectual property ownership to you, so it will need to be fixed. And third, consult with a knowledgeable business attorney if you have any questions about whether you own the valuable intellectual property for your business. There's a lot of misinformation around, and you don't want to take any chances with your most important business assets. I hope you found this information helpful. If you found it helpful, please like the video and share it with another Massachusetts business owner who wants to protect their intellectual property. Thank you so much for watching, and I'll see you in the next episode of Small Business Legal Tips.